Now, the judge is threatening to dismiss the case against the Occupy activists unless the prosecution shares vital evidence that it has refused, so far at least, to hand over. Let's get more on the case now and where it's headed. We'll talk to Greg Gladden. He's Ronnie Garza's attorney. Greg, thanks for being on the line on RT. It's appreciated. Now, what's interesting here, and we talked about it just now, is the very charge your client is facing. Tell us a bit more about that and where it's come from.
Well, it hasn't been reported in the case law very often, probably less than 10 times. It's manufacturing or adapting a criminal instrument. And if you take something that's otherwise legal and somehow adapt it or change it or manufacture something just for the sole purpose of committing a crime, and it can be the lowest level misdemeanor crime up to a more serious crime, but the fact that you've manufactured some instrument to carry out a speeding charge or some misdemeanor, it elevates it to a felony. Now, the courts were asked, you mentioned years ago, obscenity charges. There was a movie called Deep Throat that was being shown a lot in Texas, in Dallas, and Houston, and they kept arresting and charging the people with misdemeanor obscenity promotion, and they finally, and then they just reopen and make some more money showing this film, and they finally charged them with possessing a criminal instrument, a movie projector. That went all the way up to the Fifth Circuit Court of Appeals, where they found that the challenge to the overbreadth and the vagueness of the statute was not going to be knocked out on its face, but they were going to limit what this statute applies to in 3 ways. It only applies to a very narrow species of property that was specifically manufactured for a crime that can't be used for anything else.
So what's it going to do with this case, then?
It's Well, these things probably were manufactured for breaking some kind of law, but the other ways it's been limited is it's an incipient behavior. It's aimed at incipient behavior, and I had to go look up that word. But it's the beginnings. It's the manufacture and the adaptation for some future crime. It's not how something's used in the commission of a crime.
Okay.
And finally, obviously, in this case, the police officers were the only ones involved in the incipient behavior that the statute is supposed to apply to. They're the ones that purchased the materials, designed the things, manufactured them, supplied them, delivered them to the kids. So the judge threw the case out.
Greg, we haven't got a lot of time. I know you've got a lot to say about this. We haven't got a lot of time. This wouldn't be the first case where law enforcement agencies were caught infiltrating and setting up activist groups in the US, though, would it? Well,
if you've got a war on something, whether it's a war on a foreign country, a war on a communist party, a war on anti-war people going. I mean, in this day and age, there was something called fusion set up to be. This kind of sounds like Spectre in Ian Fleming novels, to monitor and ferret out domestic terrorism, this war on terror. So while infiltrating dangerous groups, certainly you would want the police to indulge in that, but when they start provoking them into doing not dangerous groups, like the Occupy people, provoking them into doing something that will marginalize them, incriminate them, and chill their activity, that's not the way we're supposed to be spending their money. And the grant money that went into setting up fusion was not intended to be spent that way.
Greg, we could talk about this a lot more. We could talk about it all night, couldn't we? But I'm afraid we're out of time. Attorney Greg Gladden, thanks ever so much for giving us a few thoughts there. We'll be
Thank you for having you.
No worries.